I may be permitted to remind you.
Not the mentioning day, Mr.
I
Banerjee.
know that, but this is a very urgent matter. I mentioned this matter earlier before your lordship. Your lordship was on 10th of November. Your lordship was pleased to observe. Kindly wait for some time and come back. Therefore, urgency is this. That unless and until this matter
I
is
remember it was an hearing matter.
yes,
Hearing
but
matter.
and your lordship I told that it should come as a motion. Your lordship agreed and said yes, it should come as motion. Therefore,
But it was at the hearing stage. There was a
no, it
calling
was
for
not
reports.
not the hearing stage. Is not matter is this. When the matter was being heard at the motion stage, they submitted a document, and the court said you just filed an affidavit. That's all. The matter appeared as a motion before in that list. Thereafter, suddenly it has come in the hearing list by mistake, according to us, according to my mistake or someone. I prayed that they let this matter come as a motion because it's a motion actually, and your lordship can decide it.
No, why it has come under the heading hearing? By mistake, or there was a direction by this court?
Yes, by mistake it has come.
There was no direction that matter to appear under
Yes,
the
the
heading
court's
hearing.
direction was there because of my
Show me the order.
because my fault is this.
No, Mr. Banerjee, please show me the order that this matter
that-
was scheduled to appear under the heading motion.
No. It is appearing as a hearing because of the direction of the court, and it was a mistake on the part of my learned junior because my mistake I tell you that it was mentioned for hearing. Now I mentioned the matter
If there is a direction, if there is a direction by the court to matter to appear under the heading hearing, how I can upgrade this matter by accommodating the matter under the heading motion?
kindly consider this. This is usually these types of matters I do not mention, but here the difficulty is this: unless I was dismissed from service, there's a statutory appeal. I preferred an appeal. They were not.
Banerjee, I have refused
not-
everybody.
not-
Sorry, I have heard you. I'm sorry.
then-
Yes, any other mentioning?
Although Monday is holiday, my lord, I should
Mention on Tuesday. I do not entertain mention. Yes. Please call the list.
Item number 1.
My lord, in spite of my communication with the ADSR, I have not got the receipt report from the ADSR, who is supposed to file the rate of the land in respect of the one.
Just a minute, let me go through my own order last one.
না রিপোর্ট দেয়নি তো আরে এডিএম কে দিয়ে কমিউনিকেট করেছি আমি ফোন করেছি My lord, I have communicated through telephone.
Just a minute.
Paragraph 7 is dot direction, my lord.
রিপোর্ট দিতে হবে সেটাই তো আমি বলছি।
Yes, have you added party? District, additional district sub-register Pandua has been added as a party. Hey, dekhi writ petition, contempt. একটা এক্সট্রা কাগজ আছে
আমাদের মিস্টার মাহাতার
এডিএসএর পান্ডুয়া হুগলি। Yes, what is your instruction?
My lord, I have communicated the matter to the ADSR by personal telephone communication and but through the ADMLR. My lord, till date, my lord, I have not received the contempt rule should be issued against him. My lord, I have communicated.
Let me pass an order.
My lord.
By name, he has been added? No.
by name.
No, my lord.
You have tried your best, but you could not
My lord.
get the instruction as it was directed by this court on last occasion.
Last occasion.
By order dated 5th December 2025, additional district sub-register Pandua Hugli was added as additional alleged respondent, or was added an additional respondent in the present contempt application. As court found it is necessary to obtain present market value of the land in question, considering area of the said land and its location.
My lord.
Stop. Next paragraph. Mr. Lolit Mohan Mahata, learned additional government pleader, is representing alleged contemners. And considering his presence on behalf of alleged contemners, court dispensed with service of notice upon
My lord.
additional district sub-register Pandua. Service of notice of contempt application upon additional district sub-register Pandua Hugli, and directed Pandua Hugli. Stop. Next paragraph. By the order dated 5th December 2025, Mr. Mahata, learned additional government pleader, was directed to obtain statement of valuation of the land in question, considering the location and area of the land based on present market value from additional district sub-register Pandua Hugli. As court is contemplating, considering the submissions made by the learned advocates representing the parties in this contempt application, to pass necessary direction for payment of valuation of the land to the applicants. Next paragraph. In spite of, stop, next paragraph. It is submitted by Mr. Mahata, learned additional government pleader, that in spite of intimating the order passed by this court on 5th December 2025, till date he has not received instructions as it is necessary from additional district sub-register Pandua Hugli. Stop. Next paragraph. Learned advocates representing the applicants as well as alleged contemners are directed to communicate this order to the additional district sub-register Pandua Hugli by 16th January 2026 and file affidavit of service on the next date. Stop. List the matter under the same heading in the daily cause list on 30th January 2026 in order to enable additional district sub-register Pandua Hooghly to file statement of valuation of the land in question, considering its location and area, taking note of the present market valuation.
My lord, may I adding?
Or market value.
My lord, may I adding?
Failing which, appropriate order shall be passed on the next date for ensuring presence of said additional district sub-register Pandua Hooghly before this court on subsequent date.
Your Honor, the adjacent area, including the land in question of the petitioners, my lord.
Next matter.
Get put.
Mr. Mahata and I am requesting both of you immediately communicate this order.
My lord.
You to file
My lord,
affidavit of service.
yes, so not only the telephone, but by way of register.
Yes.
Yes.
Okay.
Item number 418 from monthly list.
My lord, this
Is my application.
my lord, in this matter, my lord, Mr. Nilotpal Chatterjee is appearing for the alleged contempt. He was just here, my lord. The matter has been called on in court room number 1, my lord. My lord, this is
Has it been complied with?
No, lord.
May I come back before your lordship, my lord, to find out, my lord, if the reason order has been passed in terms of my lord's direction.
Yes.
My lord, there was a direction to pass a reasoned order. May I come back, my lord? May I come back to find out, my lord? I did not get the instructions, my lord. I'm sorry, my lord.
We will adjourn for a week.
I'm grateful, my lord.
It will retain its position in the combined list.
I'm grateful, my lord.
Yes, take it back. File it on the next date.
Item number 419.
For the petitioner, ma'am.
Complete.
Your Lordship, on the last occasion, I had prayed for 30 days. Your Lordship was pleased to grant me 45 days instead of 30 days. But the difficulty is that, Your Lordship, the debris which has to be carried for 300 feet. I am not taking any excuse, but Your Lordship, I have talked to my engineers. They are saying that because the G+1 is the G plus some, there is some sanction plan, your sanctioned areas. Your Lordship, if they do it hastily, the entire structure may collapse. They have told me that 1 month will be okay, and if 2 months are given, it will be better.
No, up to which floor it is to be retained?
G+1.
G plus?
G+1.
G+1.
And the other floors have been demolished. Debris are being removed, Your Lordship. And
Apart from G+1, from second story, it has been
it has been made inhabitable and demolished, Your Lordship. Demolished, debris are being removed, then further demolition will be done, Your Lordship. It is going to take, according to them, 2 months, but they have asked me that 1 month, if Your Lordship can grant, they will try their best. But Your Lordship, I feel that at least 2 more months will be required. I will be very candid.
The original order was passed on the 18th of January
You
2020.
are staying there.
Yes, my lord. I'm staying in the first floor, my lord. It's a 2024 order, my lord. 2 years.
But the demolition has taken place to certain extent.
Very little demolition, my lord. Not substantial.
You want entire demolition. So it is going on. Yes, it is delayed, not in accordance with the law. So you are waiting from 2024. They are seeking for more time, and it's nothing but a question of demolition. Demolition order has been passed. Demolition process has started. It is being demolished. Now the question is how quick it can be demolished. Now it's a matter of time. So they are praying for time to complete it. At the present moment, I am adjourning the matter for 4 weeks. let this matter appear in the monthly combined list of February 2026. You take steps to complete demolition in the meantime.
Your Lordship.
Looks at your lordship's last.
Uh, it is submitted on behalf of the alleged contemners that though demolition process has taken place, it is not complete. Stop. Some more time is prayed for on behalf of the alleged contemners to complete demolition. To complete demolition process. Stop. Next paragraph. On the other hand, learned advocate representing the alleged on the other hand, representing the applicant is complaining of delay in completing demolition. In completing the demolition of unauthorized structure at the building in question. Stop. Next paragraph. Considering the prayer made on behalf of alleged contemners, list the matter under the same heading in the monthly combined list of February 2026 in order to enable those alleged contemners to complete demolition process.
Your Lordship, if your Lordship may be pleased to indicate if a weekly status report is placed to the learned advocate, your Lordship, what is happening after a month or 45 days when I am coming, I am embarrassing your Lordship. If the OSD demolition.
Periodical, stop. Next paragraph. Considering the delay caused in completing demolition, alleged contemners are directed to forward periodical reports indicating the steps taken by the authorities to steps taken by the authorities for demolition to the learned advocate representing the alleged contemners, and those reports shall be placed before this court on the next day.
Item number 420.
Yes, ma'am. But what has been complied with, my lord?
Where is the learned advocate? What was the order?
Yes. This order.
Advocate for the applicant. Learned advocate is there for the contemner.
Yes, ma'am. But Mr. Kajol Rai was there.
What was the order? Order dated 18 December 2023.
To consider the case of the petitioner, my lord, and that has been considered while considering the matter. Hearing was going on. The erstwhile.
Last minute, they will tell the commissioner. 11th October 2018. Now, whether it has been revalidated?
No, my lord. There are some page 7 of my compliance report, my lord.
Not revalidated.
My lord, there are some construction.
Have you served a copy upon the learned advocate?
Yes.
Copy of this affidavit of compliance? No.
Yes, my lord. This number.
Where is the order of revalidation? page 7 of your.
Page 7 is the reasoned order passed with the commissioner. Not the some concept.
Issue. Contempt application is taken up for consideration when applicant is unrepresented. Next paragraph. However, learned advocate representing
Chandanagar Municipal Corporation.
Lordship. Lordship. Upon instruction of Clerk Officer Kajol Rai, who appears for the petitioner, but he's in some difficulty, he's praying for not today. So can it?
But it has been complied with already. Nothing remains in the contempt. Because our decision has been taken regarding validation, and that has to be challenged. In the contempt, the issue cannot be gone into.
Requested me to
Sorry.
apprise your Lordship, my lord.
Otherwise, I would have adjourned the matter. That's why I will read the order.
I inform you.
Yes. কি বলছিলাম? However, learned advocate representing the alleged contemner has submitted that order passed by this court on 18 December 2023 is complied with. Stop. Affidavit of compliance is filed on behalf of the alleged contemner, affirmed on January 2026, and same is taken on record. Stop. An order was passed by the alleged contemner on 17th November 2025, which is annexed to the affidavit of compliance. Stop. Next paragraph. In view of the steps taken by the alleged contemner, contempt application stands disposed of and contempt proceeding stands dropped. Next paragraph. However, this order shall not preclude the applicant to question order dated 17 November 2025 passed by the Commissioner Chandanagar Municipal Corporation if the applicant is aggrieved by such order. Urgent Xerox Service copy. Next.
I'm grateful, yours.
Item number 421.
I am for the alleged contemner, my lord. My client was required to give a, my lord, no liability certificate. Second last page, my lord, which is ready, my lord. It will be given today.
It will be.
Yes, my lord. There was an appeal. We have, my lord. My lord,
So the appeal was disposed of
yes, yes,
earlier.
disposed
As
of, my lord.
remember last occasion they.
Yes, my lord.
Why it will be? It was hard on 5th December 2025.
Yes, my lord, I'll explain everything in affidavit, but still I will be giving the no liability certificate today. The other parts, my lord, I'll explain in the affidavit.
Is also submitted that appeal was preferred. Appeal was dismissed on 19 November 2025.
Yes, thereafter we had addressed several letters seeking that the document should be given, but she has not. But in any case, since there is an order, my lord, specifically instruction, my lord, it will be issued today. Or it will be handed over to the learned advocate for the petitioner. আরে আজকেই দিয়ে দিবি সই করিয়ে কি আছে না by order of court it will be given to them. ওরা তো দিয়ে দেবো সই করে দিয়ে দেবো গোপাকে দিয়ে
What was the order?
order
23rd of August 2024. Just a
Yes.
minute. Yes, yes, it is annexed. Just a minute.
division minister. Roshu is having the division bench order. এটা বলো
Court directed by delivering a judgment on 23rd August 2024 to issue no liability certificate by 48 hours.
Yes, my lord.
Against which you preferred appeal.
There was
Now
a
the appeal was dismissed on 19 November 2025.
in the
And
in the
your
period,
headmaster is waiting.
no, my lord, in the period there was a stay of operation, my lord.
Yes, but the yes,
Thereafter,
but
after
there was an
the
appeal dismissed on 19 November.
yes, thereafter letters
From
were issued.
19 November till January 48
Letters,
hours
I
is
will
not
explain.
complete.
I have explanation. Letters were issued to her with regard to the required documents, but still,
What letters? For no liability?
my lord, that is why there are certain formalities which has to be
For
completed.
no liability certificate?
Yes,
Then we have to learn law.
my lord, kindly cease.
Then we have to learn law afresh.
If
That for issuance of no liability certificate, certain documents are required to be supplied. You
Yeah.
just forward it to the DI.
yes,
Otherwise, I will issue a rule of contempt. Enough is
give it-
enough.
I will give it to the learned advocate for the petitioner.
When?
Today.
Very well.
It is me. I have instructed the
Next Friday. Issue.
My lord,
Contempt application is heard in presence of the learned advocates representing the applicant and representing the applicant and alleged contemner. Stop. From the submissions made by Mr. Lahiri, learned senior advocate representing the alleged contemner, it appears that even after disposal or dismissal of the appeal by the Honorable Division Bench, video order dated 19 November 2025, nobody certificate is yet to be issued in favor of the applicant. Stop. It needs to be mentioned heading that video judgment dated 23rd August 2024, alleged contemner was directed to issue no liability certificate in favor of the applicant by 48 hours. As pension payment order was issued at the time of disposal of the writ petition, but same could not be disbursed due to want of no liability certificate. Stop. Next paragraph. Mr. Lahiri, learned senior advocate representing the alleged contemner, undertakes to
also records that certain letters were issued. This will I'll be bringing pursuant to my lord in the affidavit.
Mr. Lahiri, learned senior advocate, nothing is required. Please issue no liability
Yes, I
certificate
will
first.
issue, but the affidavit should come, my lord, with
No,
regard.
no affidavit is required. Issue no liability certificate, then it is to be paid. Contempt application is to be disposed of.
My lord, this
Otherwise, your contemner will face the music.
no, my lord, yeah, I have
Yes.
instructed accordingly, but my lord, may I just convey to the lord what is the difficulty when they will be uploading the no liability certificate. My lord, they will be requiring these documents. We don't have these documents, but in any case, there is an order for issuance of no liability certificate. We will issue this.
You issue no liability
Yes.
certificate,
Thereafter, whatever.
hard copy to the petitioner.
Yes, yes.
To
That
the
is-
petitioner,
that
matter
is-
ends. Because
Learned advocate for the
online
petition.
procedure is not required when there is an order
Yes,
of this
yes,
court.
yes, yes. That is the instruction basically I have given below. That is how I have instructed. My lord, I'll give it to the learned advocate. Because the
Mr.
precedent
Lyde
is
is not
coming,
senior advocate representing the alleged
but
contender.
I'll file an affidavit,
Su-
bringing all
submits.
this on record.
Submits. Nullity certificate shall be issued in favor of the shall be issued to the applicant by 48 hours. Stop. Hearing of this contempt application. Next paragraph. Hearing of this contempt application is adjourned. Stop. List the contempt application under the same heading in the daily cause list. Dated.
Advocate and record. Well, give it to the advocate and record. The president is coming today.
You give it to him.
Give it to advocate and record. To advocate and record. Lordship has said applicant. Applicant means, my lord, the writ petition.
List the contempt
Applicant
application.
or advocate.
List the contempt application under the same heading in the daily cause list. On
যদি না আসে যদি না আসে তখন কি করবে
16th January 2026. হ্যাঁ ওখানটা কি দেখো তো সেন্টেন্স
applicant or advocate. ওই তো ওকে either
না হ্যাঁ 48 hours stop একই সঙ্গে Sames could not be disbursed. তারপরে কি বললো না to the learned advocate for the applicant in course of this date.
learned advocate. My lord, there is a writ petition pending. Obviously, that will be without prejudice because lordship has granted us leave. But that is endorsement in the no robbery certificate itself.
Item number 422.
For the petition of lordship. As per the lordship direction, I have already served the affidavit of service. The order was but
Yes.
yes, but I have learned from my client lordship.
Have you? Yes.
Meantime, they came, but they have not cleared all the debris. So I've asked them to bring a photograph with the newspaper so that I can produce it before your lordship. So if your lordship will kindly take it up next Friday, I can produce the photograph since they are not appearing. Lordship gave them the liberty to comply with the order in the meantime.
No, debris have not been removed.
They came to remove the debris, but as per your lordship, they have not removed the entire debris.
Nothing has been removed.
Some has been removed. That I have got the instruction. Therefore, I am
When this removal took place,
in between, after passing of your
So
lordship.
then it appears that the order is complied with. Why they will remove in part?
Yes, they have not removed the entire. So I want to proceed.
Why they will remove in part?
They should
When they have come to remove the debris, it is presumed that they have removed the entire debris.
They have not removed. That is what my instruction.
I don't think this is a correct instruction.
I can produce the photograph. I asked them to bring the photographs. With the newspaper, I will produce the photographs next week, Lordship. Keep it here on next Friday, Lordship.
Issue. Affidavit of service filed on behalf of the applicant is taken on record stop. In spite of service of notice, and its container is not represented. Next paragraph. Learned advocate representing the applicant is directed to serve notice enclosing copy of this order upon Mr. Bishwajit Mukherjee, learned advocate who represented Kolkata Municipal Corporation at the time of disposal of the writ petition by January 2026. Stop. And stop the owner and file affidavit of service. Now, 15 January 2026. Stop. Next paragraph. List the matter under the same heading for further consideration. List the matter under the same heading for further consideration in the combined monthly list of February 2026. Next.
Item number 423.
This is first time appearing.
Where is the order?
The order is at page 18. 18, dated 13th September 2024. The order was communicated to them immediately on 19th September 2024.
Get an introduction of law.
11th paragraph will appear from page 20. Unaided school should be granted recognition.
Now, it has not been forwarded by the commissioner.
Commissioner forwarded, but according to his sweet will, not as per the DLT inspection. DLT
According to
his sweet will.
But if it is forwarded, then where is the contempt? It is a direction that the Commissioner of School Education West Bengal being directed to forward his recommendation relating to recognition.
As per DLIT report, already you lost, he recorded that there is a DLIT inspection. He cannot move excepting DLIT inspection. DLIT inspection says otherwise, he recommended otherwise. That is the contempt. Let him come how his own motion recommended something.
No, I am asking you that this order was passed on 3rd September 2024.
Yes.
After 13th September, order was passed on 13th September. Now, after 13th September, it was forwarded.
It was forwarded. Then it was forwarded not according to the DLIT inspection. Your Lordship, only safety, fire safety certificate was lacking. DLIT inspection was made in respect of 3 schools. 2 schools got recommendation as per the DLIT report. Our case that he is not sending the DLIT recommendation. He is to recommend as per the DLIT report. He cannot move according to his own motion. He is the authority to recommend the as per the DLIT report. That's why DLIT report was made. I have annexed the DLIT report. You also recorded that. The DLIT inspection was held.
Yes. Land advocate representing the
commissioner in Salt Lake.
Representing the applicants alleges violation of the order dated 13 September 2024. Stop. Next paragraph. Land advocate for the applicants is directed to serve notice enclosing copy of the contempt application and order passed today upon
Sole alleged contempt
upon the alleged contempt by fortnight from date and file affidavit of service on the next day. List the matter under the same
after
heading
fortnight.
in the monthly combined list of February 2020.
In the month of February, the contempt will be returned.
Sorry. Yes, next.
Item number 424.
For the petitioner, मतलब page number 16.
Just a minute. Whether the order has been complied with?
My lord, an appeal was filed. It is still pending. The appeal number is FME number 1347 of 2024.
No copy is sent to us regarding appeal.
Third October 2024. লিখতে হবে তো হয়তো অ্যাড্রেসে পাঠিয়েছে নাকি আমি জানি না পাঠাইনি না ওইটাতে দেখাচ্ছে তোমার হাইকোর্টের ওয়েবসাইটে দেখাচ্ছে কারণ সুপ্রিয়া আমাকে ওইটা পাঠালো
ওই জন্য নাম দিয়ে আমরা সার্চ করে দেখেছি স্পেসিফিক ইনস্ট্রাকশন রয়েছে সাজেশন
হতে পারে আমি চেক করে নেবো
4th September 2024 order was passed.
Yes, yes. We
How
filed an
long this will
appeal on
continue?
3rd.
You comply with the order subject to the outcome of the appeal.
Well, kindly allow me 4 weeks time.
When you
If
have
I
filed
can,
I have filed the appeal.
it was filed on 3rd October 2024.
2024. From 3rd October 2024 till 2026, stay application has not been heard.
My lord, I'll
Whether the stay application is appearing in the list, running in the list.
No, it is not in
Then
the list.
It is not
we are filing a memorandum of appeal and the order will be
No, I will check.
will be frustrated.
So, well,
Yes.
kindly give me 4 weeks. If I cannot come back with a stay or a final order, then
Issue. Give me the particulars of appeal.
my lord, MAT number 1347/2024.
MAT 13.
Sorry, FMA number 1347.
FMA has been allotted number.
Yes.
But till date, no stay application. Have you filed stay, Mr.
My lord, I will have to check. I could not even remember that an appeal was filed. I had to check after the contempt was served. It was served on 16th of December last month.
You have filed a memorandum of appeal and the issue is kept.
No, I don't know. I'll have to check whether
the appeal is, you are not sure whether the appeal is filed or not.
No, appeal is filed. Whether the stay is filed or not, that I will have to check. This court is telling me it is not filed. How is it?
Yes, FMA.
FMA 1347 of 2024. It was filed on 3rd October 2024.
And I have taken specific instruction whether a copy is served or not. There are no copy of
No stay, what they will serve? Nothing will they will serve. Only they are buying time by filing appeal. What can be done?
Kindly give 4 weeks. Let me.
Affidavit of service.
affidavit of service. Before my clerk will come.
Who are the contemners?
Commission, only commission. I have the
So why affidavit of service is not made ready?
my clerk go before the commissioner to affirm my
In course of the day, will
yes,
file it.
by today, my lord.
Client advocate representing applicant has undertaken to file affidavit of service in course of this day. Next, however, alleged contemners are represented by learned advocate who has submitted that an appeal being an intra-court appeal being FMA 1347 of 2024 was filed on 3rd October 2024 against the order dated 4th September 2024 and same is pending. So, however, it is submitted that till date no stay order is passed by the Honorable Division Bench. On behalf of the alleged contemners, prayer is made to, on behalf of alleged contemners, accommodation is prayed for in order to enable the learned, the alleged contemners to move the Honorable Division Bench, or in order to enable the alleged contemners to take necessary steps in connection with the appeal connection with the pending appeal. Stop. Next paragraph. Hearing of this contempt application stands adjourned. Stop. List the matter under the same heading for further consideration in the monthly combined list of March 2026.
Can we have February?
Let them take step.
Only one thing, there are two contemners. I'm only for the contemner number 1. Contemner number 2 is education department. So I'm not appealing.
Contemner number 1 করবে। However টা কি বললাম দেখো তো।
কিন্তু হাইকোর্ট করেছে না।
However, alleged contemner number 1 is represented by learned. সব জায়গায় না 1ই করবে, ওরাই অ্যাপিলটা করেছে। File your affidavit of service in course of this day, otherwise order will not be signed.
Item number 4 to 5.
এটা 4 to 4 হলো।
For the contempt number 1.
Complied with.
Yes, Lordship, PPO has been issued, but
Matter is pending, writ petition is pending, my lord.
Yes, but there was an interim order.
Interim order, my lord directed to issue the PPO on admissible. Yeah, my lord, PPO has been issued.
PPO has been issued, Lordship, but my amount is deducted.
So, the court directed by order dated 12th March 2025 to release admissible return dues.
Yes, my lord.
So, have you paid the admissible dues?
My lord, I am for
Mere issuance of PPO will not do.
my lord, I am for the DPPG, my lord. We have done my work, my lord. We have done my act, my lord. My lord, PPO has been issued, my lord.
The mere issuance of PPO will not do. You have to pay the admissible dues.
Regarding the treasury officer,
When PPO has been issued, show me the copy of the PPO.
page 36 of the contempt application.
Page 36.
Of the contempt application.
8 June 2025 PPO and till date it has payment has not been. You have not received the admissible dues. Why?
My lord, we are the DPPG, my lord. We only issue the PPO, my lord. Regarding the disbursement authority is the treasury, my lord.
No, DI is also a party. Yes. Why it has not been paid?
In contempt proceeding, we only represented the contempt number 1, my lord.
But you are the government state advocate, and who appeared for the state? Let me find out. Have you served notice upon the देखिए where is Mr. Boisho?
My lord, he's come back, my lord, from the Bangalore, my lord. From Bangalore, today he's come back.
But yesterday he appeared.
Virtual mode, my lord.
Yes.
Now
So what prevented him to appear virtually? In this matter, for where respond number 8. Respondent number 8. Who is respondent number 8?
Headmaster.
Have you served upon all? The PPO has been issued and the payment has not been made.
I will take instruction while come.
Whether Mr. Boisho is appearing in this matter?
Yes, my lord. He is appearing, but he is in flight now. He is in flight.
He is in?
Flight.
So don't give his name.
No.
Yes. Issue. Affidavit of service filed on behalf of the applicant is taken on record. Stop. Learned advocate representing the alleged container number 1 submits that PPO was issued pursuant to the order dated 12th March 2025 on 8 June 2025, but till date admissible retirement dues are not released to the petitioner. Next paragraph. As this court is informed that Mr. Bhaskar Prasad Boisho is appearing on behalf of Mr. Bhaskar Prasad Boisho, learned additional government pleader, is representing alleged container number
1.
1, comma, Mr. Boisho is directed to obtain instruction as to why till date, obtain instruction from alleged container number 2 as to why till date admissible referral dues are not released to the petitioner.
My lord, may I interrupt? My lord? Admissible dues has been released.
Oh, দেখো।
As per PPO, deducting the amount of on account of overdrawing. That is the contempt applications. My lord,
Your junior has said nothing. I have asked at least thrice. Prepare your junior accordingly and then send that to court.
Only, my lord, these portions, my lord, has not been complied. PPO has been issued. PPO has been annexed in the contempt application.
You have been paid.
I have been paid.
Now, what is the grievance?
Only, my lord, page 34. At this stage, respondent shall not insist upon the petitioner to refund the alleged excess amount. They have, my lord, in the PPO reveals, my lord, they have deducted amount on account of overdrawing from gratuity, in spite of my lord's direction. That was, your lordship, my lord, the first day I submitted before lords. Page 36, my lord, kindly see the PPO.
Yes, page PPO.
PPO, my lord, the deduction, middle portion, deduction to salary overdraw.
Just a minute. Nomination, then enhancement. Where is the deduction?
Middle portion.
Yes, deduction on account of.
Yes.
1 lakh.
10 lakh 6,008.
10 lakh 6,000.
6,872. Fixation.
10 lakh 6,872. So this is being deducted by installments, or it has been deducted from
my gratuity.
Kindly see the order, my lord.
The school authority as well as state authorities are directed to release admissible referral dues. Compliance of all formalities by 6 from date. Yes, how this refund is made.
My lord, page 30 of the contempt, my lord, order, my lord.
Yes, come to page, come to page 34.
Yes, my lord.
34.
Second paragraph, last paragraph. At this stage, respondent shall not insist upon the petitioner to refund the alleged excess drawn amount.
My lord, petition not directed to refund the overdrawn amount through the treasury seller. Here, given no direction. My lord, only directed, deducted from the gratuity, my lord.
No, I have not directed to deduct. Show me that where is the stipulation to that extent.
My lord, petition is pending now.
Maybe, but you are to pay the admissible amount.
Yes, my lord.
So what was the admissible amount that could, to that extent, the pension payment order could have been issued?
Yes, my lord.
Why you have shown the deduction?
And pension payment order issued, but last on salary is that different. That's why the admissible.
That was the issue to be decided.
Yes, my lord.
So admissible dues you could have paid.
Yes, my lord.
But how the deductions can be made? Deduction is injuncted. Come to page 34, internal page 3 of the order. At this stage, respondent shall not insist upon the petitioner to refund the alleged excess drawn amount. And you are taking refund. Only by issuing a special pension payment order, admissible dues you could have released. Admissible dues. That is permissible, but refund was not made permissible. So why you are taking refund?
Only deducted, my lord.
Why you are taking refund? You cannot.
That way I will take your instruction, my lord.
Admissible you could have paid. Disputed amount you could not, it was open to you not to pay. Why you have decided to pay the entire amount? And to take refund from the entire amount, the disputed amount. Excluding the disputed amount, admissible amount could have been paid. You have chosen the wrong path. What has happened in this matter? This is the disputed amount.
Yes.
This 10 lakhs and odd. This is the disputed that could not have been released by the state respondents in terms of the order passed by this court. What the DPPG did, entire amount released and then deducted. It was not necessary.
Reducing my basic pay.
Because I have directed that don't insist upon refund,
Yes.
but release the admissible amount.
That has been done. Reducing
But
my basic
admissible amount is not being released. The entire amount on the entire amount pension payment order was issued. Then DPPG decided to deduct it, that disputed amount. But disputed amount was never deducted by this court to be released. That is the disputed amount, Mr. Jana. What DPPG should have done it? DPPG should have issued a pension payment order for release of admissible amount excluding this 10 lakhs and odd.
No, my lord's order, my lord.
Otherwise, what will be decided in the pending contempt writ petition?
Refixation of pension?
Yes.
Whether I am
That
entitled or
refixation was done, that refixation was disputed by the petitioner. That this is not the correct refixation.
Yes.
Now, if this is a correct, if this is not correct refixation, then due to such refixation, this amount was generated. This disputed amount was calculated. Now, if refixation is wrong, you are entitled to get this 10 lakhs and odd. If refixation is correct,
no, in view of the Rafiq Mosi judgment, my lord, the refixation, my lord, the government can, my lord, the refix my last paid on, and my entire, my lord, the calculate my pay fixation right from the wrong done. But the
what is admissible? What is admissible amount?
Admissible amount, my lord, the
Court directed to pay the admissible amount at this stage. Rafiq Mosi will apply at the final hearing stage.
Admissible amount at their objections.
Yes, you are correct.
Pay has been reduced.
You are correct.
Last pay has been reduced.
You are correct that Rafiq Mosi will apply paragraph 18 and no refund is permissible. But that is to be decided at the final hearing stage.
No,
while
that is
refixation, DPPG has done the right thing, has done the wrong thing. Because if court directed to release the admissible amount, deducting disputed amount, admissible amount could have been paid. And this amount could have been withheld and subject to result of the writ petition. That DPPG did not do.
DPPG, my lord, the DPPG my lord, interpreted the.
You are correct that ultimately, if refixation is found to be correct, even then this refund is not permissible.
Yes.
Because after determination, that is not, you are not,
that is why
authorities are, but that issue was not decided at the motion stage by this court.
No, my lords, my lord.
Issue was left open at the time of final hearing, but considering the fact,
admissible pension.
file your affidavit.
And only they have interpreted, my lord, the
Get it out.
refund the amount or, my lord, the
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. It appears in terms of the order passed by this court on in terms of the order passed by this court on 12 March 2025. Pension payment order was issued on 8 January 2025 and retirement dues were released. Stop. It is contended on behalf of the applicant. Petitioner applicant kore dibe. It is contended on behalf of the applicant that in violation of the order dated 12 March 2025, rupees 100 6872 was deducted from the gratuity of the petitioner. Stop. Next paragraph. On behalf of the alleged contemner, it is alleged contemner. You are representing both the contemners.
No, my lord, only DP.
On behalf of the alleged contemner number 1, it is submitted that video order dated 12 March 2025. Petitioner applicant is entitled to receive admissible return dues, not the entire dues. Stop. So according to the alleged contemner number 1, VDA pension payment order dated 8 June 2025, deducting overdrawn amount, petitioner in applicant in effect was permitted to receive admissible return dues. Stop. Next paragraph. Learned advocate, alleged contemner number 1 is directed to file affidavit in opposition to this contempt application by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Stop. Next paragraph. List the contempt application under the heading contempt hearing in the monthly combined list of March 2026. একটু বাদে ডাকবেন, কথা বলুন। ওই যে ডাকো ডাকো ডাকো।
Item number 4 to 6.
Item number 4 to 6, my lord, I am for the state.
Almost, my lord, this is also same, page 25. Release the admissible return dues without insisting upon the petitioner to refund value of excess.
Where is the pension payment order?
Page 29.
Page 29. This amount, my lord, has been released.
Just a minute.
We are about to release for this 1,97,000. 25.
As per each and every cases, DI approved the DI sanctioned the pay fixation. At the time of retirement, Joint Director of Accounts.
No, but where is the wrong in it? I am also rethinking it. Though I have passed an order in previous matter, both the advocates are there. Adjusting the disputed amount, entire amount has been paid. So admissible dues has been paid. Further refund was disallowed.
Further, without insisting upon the to refund the excess amount. That means, Your Lordship's language, my lord, the respondents, my lord, so far my understanding, either to refund or to deduct. Since the pensionary benefit was not released at the time of passing Your Lordship's order, that is Your Lordship's order said that the without insisting upon the refund.
Please.
If it is PPO has been issued, then without deduction. This is the, my lord, the so far my understanding, my lord, the either refund or deduction. They cannot deduct any amount in view of the Rofingmesi judgment. Even there is a wrong, my lord,
Same order, file your affidavit. এসো ওই অর্ডারের ইয়েগুলো চেঞ্জ হবে
Well, this amount has been already been released. 1,97,462. That
but you have refunded 1,90,000 this amount 1,97,462.
this amount has been released on 18 December 2025.
You have released this amount.
Release this amount, my lord. This is my instruction. My
Then
instruction.
nothing remains.
My instruction is that, my lord.
It has been complied with.
And in that respect, a letter also.
You don't have instruction.
My lord, a letter was also written by the Director of Pension Provident Fund.
বসো। Admissible letter. GPA. What is the full gratuity amount? GPA?
The amount,
Where is it written here? Yes, net gratuity for 611,0226 probably.
as it appears from.
Net retiring gratuity 611,026.
6110. No, gross gratuity 8,08,488. Just for 2 lakhs. And now the after deduction 6,11,026. Melody, gross.
Where is the gross gratuity? Where is written?
Melody, just melody.
Net retiring gratuity is there.
Just 2 lakhs above.
Above.
Yes. Gross gratuity. Gross retiring gratuity 8 lakh because you are a non-teaching staff. Yes. 8,08,480.
Okay, thank you.
ফোন করেন ফোন করেন
Yes, a revised pension payment order has been issued. It is dated 6. No, this is the old pension payment order.
Yes.
Where is the revised pension payment order?
Well, letter was written that 18 December 2025.
No, this is letter dated 18 December 2025. It is stated that excess on amount of rupees so and so may be released in favor of the petitioner. And in this regard, revised EPPO vide EPPO number so and so dated 16 June may be kindly be issued. That is 18 December 2025. Revised EPPO. EPPO number so and so dated 16. Where is the payment? Show me. Maybe released, but where is the payment?
No, that, my lord, I have to take instruction, my lord. Because this much instruction, my lord, they have sent to me. Then
So, you are submitting that it has been paid. Where it has been paid?
No, over telephonic information, my lord, they have said, but there is no document, my lord, so I could not submit that.
So you take steps in the meantime. I am keeping this on record. that you take steps and release the amount in the meantime. As it is decided, as memo has been issued pursuant to the order passed by this court, by the DI on 18 December 2025. And it has been addressed to the Director of Pension. What is your instruction?
I have no instruction.
Yes?
Again, I have no instruction.
Since both the advocates are appearing here, আগের order change করো তো issue. Otherwise, there will be a dichotomy in similar matters. তুমি আগে এই অর্ডারটা নিয়ে নাও।
কি করেছে তো ইনস্ট্রাকশন তো
Affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Learned advocate representing alleged container number 2. Has submitted that alleged container number 2 vide memo dated 18 December 2025 addressed to the alleged container number 1, addressed to the Director of Pension, Provident Fund and Group Insurance being alleged container number 1, requested to release an amount, requested to release rupees koro, an amount of kete dao, requested to release rupees 197462. And if necessary, a revised pension payment order be issued in favor of the petitioner for due compliance of the order passed by this court on 20 May 2025. Stop. Next paragraph. By order dated 20 May 2025, court directed the concerned state authorities to release admissible referral dues, including pension to the petitioner, without insisting upon the petitioner to refund alleged excess drawn amount. Stop. Therefore, at this stage, alleged containers number 1 cannot claim refund by issuing pension payment order dated 16 June 2025. Stop. Next paragraph. Respondent number 1 is directed to take necessary steps for release of rupees 19462, 197462, 197462, rupees 197462. Taking note of the memo dated 18 December 2025 issued by the alleged container number 2 immediately. Stop. List the matter under the same heading for further consideration in the monthly combined list of February 2026. Again, matter to both side আছে. Yeah. Wait. Mr. Jana, wait. Let this matter be taken. ওটা একটু দাও তো, এটাকে ঠিক করে দিও ওটাকে। আগের ম্যাটারটা জাস্ট আগে কি বলছো? দিয়ে দিয়েছো ছবিটা। Right, for future fixation relating to pension, this rider was inserted.
Yes.
Nothing else, but whatever has been paid, that cannot be refunded at this stage. Only that is relevant for the purpose of fixation of pension. আগের ওটাকে চেঞ্জ করো, বলে দিই। The contempt application is heard in presence of the learned advocates representing the applicant, and alleged container number 1. Stop. However, in spite of service of notice, alleged container number 2 is not represented. Stop. Next paragraph. In terms of the order dated 12 March 2025, pension payment order was issued on 8 June 2025. But rupees 1006872 was deducted from the gratuity of the petitioner, from the gratuity of the applicant, which according to the applicant is not permissible in view of the order passed by this court on 12th March 2025. Next paragraph. Video order dated 12 March 2025. State authorities were directed to release admissible retirement dues to the applicant but state authorities were directed not to take refund or not to claim refund from the retirement dues of the petitioner. Stop. Next paragraph. In view of the order dated 12 March 2025, at this stage, by issuing pension payment order dated 8 June 2025, alleged container number 1 is not authorized to deduct amount towards refund from the gratuity, as it has been done. Stop. Next paragraph. Next paragraph. Alleged container number 1 is directed to issue revised pension payment order, directing issue revised pension payment order and release 100,687 rupees 100,6872 to the petitioner by by 4 weeks from date. Stop. List the matter under the same heading for further consideration in the monthly combined list of March 2026. Release it. Now I recall that it was only for the purpose of refixation of pension. You can pay pension as per your calculation, but no refund.
And probably it has also been probably being released.
Otherwise, there is no difference.
Yes, madam.
Which was the situation which was existing prior to the order passed by this court and after the order passed by this court.
Yes,
This PPA was to be passed. On being aggrieved, writ petition was filed.
Yes, madam.
Yes. Dako.
Item number 4 to 7.
I am for the petitioner. This is the transfer matter, page 94, my lord's order. My lord's order please to previously recommendation was made by the School Service Commission to a particular school, but the school was a minority institution. You also kindly see the order, page 94.
Last occasion, no one represented the content. Whether the order has been complied with.
The order, now the School Service Commission wrote a letter in pursuance of direction. The particular school, this is directed to re-recommendation to any other school, because that school was a minority institution. I have opted a school, Kiljola High School, but the School Service Commission, chairman of the School Service Commission wrote a letter pursuant to lordship direction that that vacancy has already been reported to the second list. So, my lord, I have challenged that by filing a writ petition.
So nothing remains
after the contempt application, because I have suggested that my client might not be no order can be passed in the contempt proceedings. This is the other situation, because the School Service Commission has not deliberately violated. They have said, my lord, the vacancy has been reported.
Court directed to allow to recommend the petitioner to a particular school.
To any school nearby my residence. But I have opted that, my lord, kindly see the order, page 37. This is also violation, but
in contempt, the issue cannot be gone into. Page
94 probably, my lord.
Viral, since you have not, you have already filed a writ petition in pursuit of your remedy, then nothing remains. So there is no use of entering into this issue. Learned advocate representing the applicant submits that contempt application is not maintainable and petitioner has filed a writ petition seeking necessary directions. Next paragraph. In view of aforesaid submission, contempt application stands dismissed. However, this order shall not preclude the alleged. However, this order shall not preclude the applicant to take steps in accordance. parties to act on the server copy. Yes, call the next one.
Item number 428.
Yes. Why?
I'm led by Mr. Shritudas Gupta in this matter. Matter needs to be argued. Lord, I have served the contenders. Lord, he is not present in the court. Some personal.
He has not come to court. Why? What has happened to him?
No, there is some personal crime. I'm not aware of. But I have served the affidavit of service.
Have you served notice? File it. Affidavit of service filed on behalf of the petition, on behalf of the applicants are taken on record. Stop. Next, however, on behalf of the applicants, accommodation is paid for. Stop. Respondents are not, alleged contemners are not represented. Stop. List the matter under the same heading for further consideration in the monthly combined list of February 2026. Next.
Item number 429.
My lord, I am appearing on behalf of the Alice contemner, my lord. I am very sorry, my lord. On last occasion, I failed to appear, my lord. My lord's order has been complied with.
Complied.
Your lordship passed an order on 5th December 2000, directed to sharp copy on the administrator.
Yes, join, my lord.
Just a minute.
ডিসেম্বরের টাকাও পেয়ে গেছি, ডিসেম্বরের পে স্লিপ দিয়ে দিচ্ছি।
ভালো সব দিয়ে আছে।
What was the order passed by this court?
Case 16, relevant case, case 19. Paragraph.
Order dated 1st July 2025.
Relevant page 19, paragraph 10 and 11. I am reading.
Just. So he has joined already petitioner.
Yes, pay slip also I have given, page 4.
Yes, I have for the month of December.
Serial
I have
number
written
8.
this challenge. I have written this. These are in fact. No, your lordship passed this on 1st July 2025.
Yes, already order has been complied with.
When it is complied, you are kind of visualize
Oh,
this. this is the delay compliance because I have been suffering. I am entitled to join after the setting aside of this order. Now neither the DI nor the administrator has allowed me to join, in spite of giving several letters.
Now you have joined.
Now in the month of December, 2nd December 2025, I have joined. But if I join in the month of July, then I cannot suffer for 6 months. And similar things was happened on the earlier occasion when my approval was withdrawn. I challenged this order before this court. Court successed the order, but there also 5 months have been delayed to allow me to join. Thus, in the contempt of court passed an order. Why you will be suffered for the delay compliance? But this is the condition on the earlier occasion, the contempt application. This is the order. But this is going on the part of the DI. And the earlier contempt order.
You have joined on 2nd December 20. You have 2nd December.
2nd December.
Issue.
And only one thing. I will be smart. But on the earlier occasion, same things happen. Oh, but I am suffering.
In my order, how I can go beyond it? I have set aside that order of termination. Thereafter, consequential steps were required to be taken.
After 6 months.
So for that, you take steps. You did not work during this period because of their laches. Now you take appropriate steps to prevent you. But in the contempt, that issue cannot be gone into.
Well, kindly see this order also. I am requesting the lordship for my satisfaction.
I have set aside the termination order.
My lord.
So therefore, you joined, but this joining is delayed. For that, this court is not there to advise you.
No, I am not. Only one.
That is considered in presence of the learned advocates representing the applicant, and
for delay compliance, they will not be. The DI should be penalized for that purpose. On the earlier occasion, the same thing has been happened.
And alleged, you are representing both the contemners and alleged contemners. Stop. Next paragraph. The learned advocate representing the alleged contemner submits that order of this court dated 1st July 2025 is complied with, thereby permitting the petitioner to join the post of assistant teacher in
Bengali.
in Bengali in Metekona Maulana Abu Tahir Senior Madrasa, Birbhum,
Yes.
on 2nd December 2025. Stop. Memo dated 19 November, copies of the memo dated 19 November 2025 issued by the District Inspector of Schools within bracket AC close bracket Birbhum, and memo dated and letter dated 29 November 2025 issued by the administrator Metekona Maulana Abu Tahir Senior Madrasa within bracket Fazil close bracket Birbhum, and the letter of the applicant dated 2nd December 2025 at the time, which was submitted before the administrator of the said madrasa at the time of administrator of the aforesaid madrasa at the time of joining, are taken on and salary requisition statement are filed today and same are taken on record. Next paragraph. In view of compliance of the order dated 1st July 2025. Contempt application stands disposed of and contempt proceeding stands dropped. Urging Xerox certificate copy.
Now, however, but you can put dates to delay compliance. But কালকে দেখাই দিয়ে
এটা করে দাও তো। However, this order shall not preclude the petitioner to take steps in accordance with law if petitioner is aggrieved by the delay caused in permitting him to join the post of assistant teacher.
I'm deeply obliged, my lord. I am led by Mr. Bandyopadhyay Singh.
Yes,
Led by Mr. Shishanu Bandyopadhyay.
where is he?
There is another court, my lord.
দিয়ে দেবে।
I'm giving.
Next.
Item number 430. My lord, I am appearing on behalf of state company.
Yes, fixation of pay.
Allow me to submit the compliance report.
No, have you fixed the pay?
My lord, I have fixed and I have already remitted the amount in the month of November, my lord. On last occasion, in the month of December, petitioner is as making submission before your lordship that I have not remitted. Remitted.
December 2025.
I have directed that to pay come to this order
দেখি compliance একটা দিন আমাকে তো।
2nd January 2025.
My lord.
Now, just a minute. Fixation of pay of the petitioners in postgraduate scale of pay from 14th September 2007.
After payment of area.
Area has been paid.
Area paid.
Yes.
After
Where is
payment
such
of
fixation? Show me.
My lord, please come to the
Yes.
first page, paragraph number 3, my lord.
Just a minute. That's what I meant to mention.
Page number 7, my lord. Annexure is attached
Just a minute.
thereof.
Page 7. Annexure R2. Yes.
Page number 7, my lord.
7. Just a minute.
Annexure 2.
Excellent.
একটা দিয়েছে চিঠি।
দিচ্ছে।
এটার সাথে মিলছে কেন?
Your lordship was directed from the 12th May 1999. I have fixed it from the said date, my lord. My lord, please come to the page, page number 9.
Just a minute. Just a minute. But I have directed from 14th September 2007. But do you have the copy of this
Just now
Report I have given, my lord.
I have not gone through it, but I just
file a compliance report? Because it's a fixation of pay, file a compliance.
My lord.
Issue. Learned, Mr. Shahi, learned additional government pleader, representing alleged contemner on instruction submits that pay fixation is made allowing postgraduate scale of pay,
My lord.
allowing postgraduate scale, allowing postgraduate scale to the petitioner in terms of the order dated 2nd January 2025. Stop. Next paragraph. Alleged contemner is directed to file an affidavit of compliance by fortnight from date. Stop. List the matter under the same heading for further consideration in the monthly combined list of February 2025.
My lord.
By 3 weeks করে দাও.
Deeply obliged, my lord.
Let it be on record that you have made the fixation.
My lord.
You take it back. Take it back. Next.
Deeply obliged, my lord.
Item number 431.
Which order you are complaining of is violated?
27.
Page?
Page 27 of my container.
27.
This is the retired headmaster. Disciplinary proceedings was going on and compulsory internment punishment order was passed. That order was challenged to the appellate authority. Appellate authority set aside the.
Last minute, let me go through this my own order. Having considered. So you are seeking provisional pension.
Already.
It has not been paid.
Granted, thereafter stop from the month of September 2025.
Now, what is the present position relating to the proceeding which was required to be initiated as per the direction of the appellate authority?
But not completed. As per
Issue.
lordship, 6 months.
Lawyer advocate representing the applicant alleges violation of the order dated 5th March 2025. Next paragraph. Lawyer advocate for the applicant is directed to serve notice, including copy of the contempt application and order passed today upon the alleged contemners by fortnight from date and file affidavit of service on the next date. Stop. List the matter under the same heading for further consideration in the monthly combined list of February 2025. Next matter.
Item number 432.
I am for the petition. There is two contemner director change.
First time.
First time.
Where is my order?
That is the page number 29. Start from page 29 provision. The relevant portion will look page 30. Having considered.
Just a minute. No decision has been taken by the director of
Yes,
Madrasa.
yes, my lord, what has happened, my lord? You will kindly see the page 33. Decision was taken. Now, last paragraph. Now, having regard to the findings of the case and on perusal of papers, custodians, documents submitted by such and such, DI of the need to be
And the considered
and fresh documents to be submitted to the undersigned for future course of actions. The DI not 24 Calcutta is hereby directed to go through the all the papers of pay of the petitioner and Mohammed Habibullah and issue a fresh pay fixations of the Sokat Hussain Piada at par with the pay of Mohammed Habibullah, keeping in the view 151 such and such. My lord, what has happened, my lord? Then, my lord,
How this contempt is
my lord,
maintained?
what has happened, my lord? He again called me, page 34, and my lord passed an order, and handed over a copy of the order of DI. Here, my lord, he shows, my lord, I am getting less salary than Mohammed Habibullah. Page 34. Page 34.
For that, you have to initiate take steps, but in a contempt, the issue cannot be gone into.
Because, my lord, first, my lord, they have taken.
Because rightly or wrongly, the director has passed an order that
at par. Your lordship, in parsonage of.
But you are not getting the benefits at par.
I am not getting the benefit at par. Though, my lord,
so then you have to initiate a proceedings for implementation of this order. In a contempt, that issue cannot be gone into.
So, my lord, on one hand, my lord, they say, my lord, it is at par. But, my lord, at the same time, my lord, immediately, my lord, say.
Court directed director of Madrasa Education to take decision. Madrasa Education took decision, directing that the petitioner to get the benefit at par with another candidate.
Yes.
Now, this is the decision. When this decision is taken, everything relating to the connected writ petition is
And
ended.
Again,
Now, if that order of the director of Madrasa Education is not implemented,
yes,
how this contempt petition is maintainable?
my lord, again the director.
Because there is no direction to that extent for which you are seeking initiation of contempt.
They have flouted the order of the court because, my lord, again they called me and I handed over these documents. So, my lord, and one hand, my lord, says
for which Mr. Borua, you have to file a fresh writ petition.
My lord, when says as per your lordship direction.
Because already that decision has been taken.
At par. At par.
If this decision is not compliant with, it will be gone into in contempt.
So on one hand, my lord, they have complied the order.
Today I direct the authority to pass an order. Order is passed in your favor. That order is not complied with. Whether the remedy lies in contempt.
And immediately they have changed
the
order. Immediately they have changed the order, my lord.
In contempt application, it is learned advocate representing the applicant submits that order dated 13th August 2024 passed by order dated 13th August 2024 passed in the connected writ petition is violated. However, on hearing the petitioner, it appears that in terms of the order dated 13th August 2024, alleged container number 1,
yes,
passed order on 13th May 2025. Stop. Such order dated 13 May 2025 is part of the contempt application. Annexed at pages 32 to 34, 33. Stop. Stop. Next paragraph. It is further contended on behalf of the applicant that order dated 13th May 2025 is not complied with. Stop. Next paragraph. Since decision has already been taken by the alleged container number 1, court finds order dated 13th August 2024 is complied with. Stop. Hence, contempt application stands disposed of and contempt proceeding stands dropped. Next paragraph. However, this order shall not preclude the petitioner to take steps in accordance with law if petitioner is aggrieved by the steps taken by the alleged contemners. Next.
My lord, shown the appear behalf of the state, my lord, is matter, my lord.
Contempt on the first day is not required.
Copy has been sharp, my lord.
Maybe. If you appeared, you entered your appearance. Sorry. Contempt application, unless a notice is served, where is the question of appearance?
Item number 433.
Yes.
Compliance of lordship's order.
Yes. Order dated 20th June 2025. Who has violated the order of order?
Chairman.
Chairman has not taken any decision.
No. No, DI has referred with chief medical officer's recommendation at page 90 and page 23, Miller. What is West Bengal
After issuance of
contempt later? Kindly see, Miller, 20.
Where is the medical report?
Medical report we have sent to.
Have you annexed the medical report?
No. Okay, we are not getting it as because DI has directly sent to the.
Now the chairman has not taken any decision till date.
He wrote a letter, Miller, on 22nd September 2025 after received our letter of not violation of willful violation of the Your Lordship's order.
Where is that letter?
That is at page 23.
Page 23.
First Miller, our letter is kindly see 20. 10th October 2025, we have given a letter. And Chairman Lord issued notice on 22nd September, which we received on 16th October 2025.
after the letter was received by
After receiving our letter, contemplated.
But this decision has been taken by the Secretary of the West Bengal Central School Service Commission.
Yes.
So the order is complied with. You may be agreed by the order. Order may not come in your favor. But how contempt is maintainable?
They are saying that the school said there is no vacancy. It is not the school concern. DI will say.
They are saying that at the time of submitting your transfer application, you have indicated 2 schools.
Yes.
In both the schools, vacancies are not there.
Still-
Where you are to be transferred? Where you are to be transferred? Because you have indicated in your transfer application 2 schools.
Any school, Milord,
But that issue can, for that you can challenge this order of the Secretary of the West Bengal Central School Service Commission. But how in a contempt I can exercise? It's a special jurisdiction.
Milord, contempt is as because, Milord, school headmistress cannot say that there is no vacancy.
Yes.
DI will say.
No. School headmistress, school authority generally issues. But in any event, the decision is taken in view of J.S. Parihar's case of the Supreme Court. After the decision is taken, contempt does not lie. Try to appreciate my predicament. I am not hearing the writ petition in order to appraise or in order to examine the validity and legality of the order of the Secretary of the Commission. That issue cannot be considered in the contempt jurisdiction. Contempt, I will find out whether there is violation or not. If decision is taken,
Your Lordship,
decision is
that should
taken, everything then the order passed by this court is complied with. Now you may say that this decision is not correct decision, but for the purpose of testing the validity of that decision, contempt is not an option. Option is to file a fresh writ petition.
Milord, one thing, Milord. Your Lordship directed to take action in accordance with law. In accordance with law means, Milord, that the medical verification, all these, which was sent by the DI. And it is a medical transfer, Milord. Whether there is vacancy or not, that is not answerable.
Who was respondent number 3? Issue. A learned advocate representing the applicant alleges violation of the order dated 20 June 2025, passed by this court on the corrected writ petition. Next paragraph. Learned advocate for the applicant is directed to serve notice enclosing copy of this contempt application and the order passed by this court and the order passed today upon the alleged contemner by fortnight from date and file affidavit of service on the next date. List the matter under the same heading for further consideration in the monthly combined list of February 2025.
Should we serve DI to notice also?
No. Alleged contemner.
Item number 434.
Yes, where is the order?
Of headmaster.
The commissioner has not taken any decision.
On 7/7/2025.
Where is that notice? Yes, page 23. 23. P4, page number 23. 7 July 2025. Page 22.
22.
Yes, annexure P3. Now, no decision has been taken by the commissioner. You appeared before the commissioner, petitioner appeared before the commissioner. Hearing was conducted on 18 July. But thereafter, no decision was communicated. Issue. Learned advocate representing the applicant alleges violation of the order dated 9 June 2025 passed on the connected writ petition. Next paragraph. Learned advocate for the applicant is directed to serve notice enclosing copy of the contempt application and order passed today upon the alleged contemptor by fortnight from date and file affidavit of service on the next date. Next paragraph. List the matter under the same heading for further consideration in the monthly combined list of February 2025. Next. Yes. Yes, yes. Give your appearance, Mr. Vishwas. হয়ে গেল এটা? Yes, yes.
Item number 2 from daily list.
That I appear for the petitioner under my activities also.
For a state respondent. Against the answering respondent number 2 is the district judiciary.
Yes.
Oh. But I'm challenging under the impugned order is a.
When you have served upon the respondent number 2, 3, and 4.
My lord, I have served on my lord 24/12/2025, and my lord, it was delivered on 2nd of January 2026.
Your grievance is against the Judgeship of North 24 Parganas. So without hearing them, it's a service matter. So they are to be heard. What you are praying for?
My lord, I'm praying for my lord, setting aside of the order, my lord, which has been passed, my lord.
By the district judge?
By the district judge.
So then district judge has to be heard.
I can serve a notice and come back.
Who appears on behalf of?
Kindly see the last order which has been annexed. Well, kindly come to page 74.
Page?
Page 74.
So there I only appeared for the district judiciary.
District Judge is a Porna Chaudhary.
Page 74.
Page 74. This is a coordinated bench order. Annexed at page 20, page P23.
In the first round of litigation, this is the
Connected with that, completely different aspect. Only this order said to dispose of the representation at the earliest, different petition.
what is your prayer by setting aside this order? By what you prayed for? Which claim was refused?
I want the Shetty Commission benefit, not in a way that initially I was appointed as the process server. Then my service was confirmed in the year of 2015. After that, there was a notification by the district judgeship that whoever wants to be the seal bailiff or court bailiff, they can apply. In view of that, in order to get better facilities, I have been there, and I was appointed as the seal bailiff there. Thereafter, the recommendation of Shetty Commission came, whereby a window has opened that if anyone who wants to be a part of who wants to be promoted as the LDC, the lower division clerk, they can apply. The requisite qualification would be requisite knowledge in English and along with the computer studies. 25% should ought to have been taken from this court bailiff or the process server. Since I was a court bailiff, I intended to be appointed as the LDC. Then there has been a gradation list which has been published by the district judiciary. I have given my representation stating that to consider myself. My representation was pending after the gradation list was published. In the earlier round of litigation, the order that I have annexed, there was different petitioners. In that, the Honorable Coordinate Bench said.
In that writ petition, you were not a party.
I was not a party, and my claim was nowhere there. That's a complete different litigation. So, my representation has been dealt with and it has been rejected, stating that since I have already opted
for the seal bailiff, for the option of seal bailiff, now I cannot be promoted to LDC. Well, my humble question before the respondent number 2 is that there was no option given to me. When the Shetty Commission is in force, it goes back to the retrospective end. So, a window opens there.
So now you are working as bailiff.
I am working as the seal bailiff. I want to be considered for the post of LDC. My increments would be better. I will have a better facility in the future.
According to the respondents, that window is closed so far your promotion to the post of LDC.
Yes, madam. And that is why I have also made an RTI. So in order to know that whether any option has been given to me or not. Well, till date, the RTI is also pending. There has been no reply from the end of the district judiciary. But that is only my limited grip.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. In spite of service of notice, High Court administration. In spite of service of notice, Registrar General, High Court, Calcutta, as well as District Judge, not 24 Parganas, Barasat, being respondent numbers 4 and 2 respectively, are not represented. Next paragraph. Learned advocate representing the petitioner is directed to serve notice. Directed to serve further notice upon the District Judge, not 24 Parganas, being respondent number 2, and the Registrar General, High Court, Calcutta, being respondent number 4, enclosing copy of this order by by 16th or by 19th January 2026. Stop. List the matter under the same heading for further consideration on 4th February 2026. Next.
Item number 2. Item number 3.
Well, right. Petitioner in this matter. My lord, I'll be very candid. There has been a problem by my clerical staff. Your lordship, this matter was returnable today. My lord, the date has been given to them on 13th. Probably, my lord, that is why they couldn't appear today, your lordship. I'm challenging the order passed by the district.
No, to be listed on 9 January 2026.
My lord, but the notice that has been served, my lord, is written as that matter will appear on 13th of January. Probably that is the mistake on our part.
Issue. At the time of call, accommodation is prayed for on behalf of the petitioner. Stop. Hearing of this matter stands adjourned. Stop. List the matter under the same heading for further consideration on 9th February 2026. Next.
Item number 4.
Employee of CHC Millets, retired
Waiting for the state respondents.
Provident Fund.
Who is appearing for CSTC?
Mr. Bihari was there, Here was also there.
If I may, because I am director of instruction, Your Lordship,
Your instruction is not required. Because CSTC is the main authority. I know these matters are being taken up by this court regularly. You are not a contesting respondent in this matter. Yes, what you are praying for?
80% of Millet Provident Fund.
When you retired?
That I retired on Millet 30th of June 2025. May I hand up the similar order?
Yes, first tell me that what you are claiming.
Yes. Let 80% of Millet Provident Fund which has not been paid to Millet, and belated payment of Millet gratuity.
Interest on.
Yes, interest on Millet.
Interest on.
Belated payment of gratuity. And
Gratuity.
leave salary.
Leave salary and
gratuity.
Gratuity and leave salary.
Both. And Millard, 120 days, Millard, that your lordship had the last occasion directed consideration to give
120 days of what?
of leave salary, Millard, which had not been paid. 180 days leave salary had been
So you are
calculated.
claiming 80% of provident fund and interest on gratuity and leave salary.
My lord.
Then 120 days leave encashment benefits.
My lord. For that, your lordship had directed, given me leave to Millard.
In all matters, you have received, you have brought copy of the order.
Yes, yes, all separate orders. Same order, Millard, on all separately.
Similar orders are being passed regularly. So you need not obtain any instructions in this matter.
If I may just enlighten you about one thing. In the morning, I had a talk with the authorities. Though it is a informal communication, the state, the Transport Corporation has made a application before the state authorities for release of fund for addressing the issues of the petitioners. Now there is a stand. They have asked us to obtain written instruction and to seek for some adjournment so that they can give written instruction. Rest I leave upon this.
Instruction for what?
Instruction whether the amount of fund as paid for by the transport authorities, whether they are in a position to give it or not.
Even then, petitioner is entitled.
Not
Petitioner has worked.
Not
It does not depend upon your instruction. Petitioner worked, then retired on 30th June 2025. Till date, 80% of provident fund, it is his
certain
money has
amount
not been paid.
Certain amount has been.
So let me direct the state respondents to directly pay it to the petitioner.
Sure, Lord.
On the next date, when you will take instruction,
I leave it to you. Lord. Since transport
let me direct the state government that it is their organization, the Calcutta State Transport Corporation, they are unable to pay because of financial constraints. Let the finance secretary pay the amount.
No. As I have placed before your lordship, this was just a communication between the councils. No?
Make submissions where it is required.
Lordship. I just, because in the later stage it may come up that I haven't disclosed this.
Otherwise, before the High Court, you will invite travel. Because Calcutta State, it is Calcutta State Transport Corporation. Calcutta State Transport Corporation is under your aegis of the state government. Now, if they are unable to pay the benefit because of financial constraints, I will direct your finance secretary to directly pay it
Lordship, since they
to
are
the
not
petitioner.
representing, let's not take into consideration what I have said because it was a
On the next
communication
date. And to that extent, I am passing an order, obtain an instruction. Yes. But where is Mr. Bihani or his junior?
That's the difficulty.
Hold on.
Right now.
Petitioner was under the contributory provident fund scheme. interest on provident fund, you are not claiming.
No.
Yes. What is your instruction regarding item number 4?
Lordship, possible I missed out here.
Petitioner is seeking 80% provident fund and interest on gratuity and leave encashment benefits and consideration of representation for consolidation of leave encashment benefits against 300 days, not against 180 days. That has already been.
Yes.
So let me pass an usual order,
Yes,
which
Your
are
Lordship,
passing.
Your Lordship
that
already
is,
decided. Already decided similar matter.
By 6 weeks, 80% provident fund to be paid. By 3 months, interest on gratuity and leave encashment provident fund is not claiming. And a representation is to be made if leave is granted to make a representation by fortnight for consolidation of leave encashment benefits against further 120 days, and if it is made, then the managing director shall decide the same in accordance with law. এটা করে দিয়েছি, তুমি দেখে নিয়ে করো, disposed of. Next.
Item number 5.
My lord, item number 5, I'm praying for not today, my lord.
My lord, there is a judgment of my lord that was passed on 2nd of January 2026 relating to the tattoo is concerned. Yesterday, that was also published in Times of India. My lord, I hope there is no merit in the matter.
Petitioner is praying for time.
Not today, my lord. I'm praying for
My
not
lord,
today,
then
my lord.
keep it some down.
Well, if you have difficulty, send your junior, I'll accommodate. Not today.
Item number 6.
Let similar matter, Millard. May I order? Let retired on 28th of.
Yes.
28th
Just a minute.
Fine.
Retired on 28th.
28th of February, Millard, 2025.
What you are claiming?
Same claim, Millard, 80% provident fund which had not been paid to me.
Interest on gratuity and leave salary.
And that unpaid amount of 80% that is there, Millard. And
Interest on gratuity, leave salary, and
120 days, Millard.
Leave encashment.
Yes.
23.
You are for the state.
I'm for the state, my lord.
চার থেকে মানে 10, 5 থেকে 10 আর 13।
Disposed of.
I'm grateful.
Where is Mr. Bihani?
Lordship, he is on legs, Lordship.
Yes.
Item number 7.
That's similar matter, Milan. That retired on Milan.
Anybody is appearing for, you are for the state.
Millet. Retired on Millet 30th of November 2024.
80% PF.
My
Interest on
gratuity and leave salary related.
and leave encashment, leave salary for 180 days.
120 days.
120 days. See, 180 days has already been paid.
Gratuity has not been paid for, sir. Gratuity has not been paid for. Where is the gratuity?
At 30th November 2024.
My
ঠিক আছে।
disposed of. দেখো,
May have you leave to mention a matter about.
it is not the time to mention. Mention on at the morning, at the first sitting of the Yes, call the list.
Item number 8.
Let CSTC by 80% millet provident fund and
When retired?
retired on millet 31st of May 2025.
What you are claiming?
Let 80% of unpaid provident fund, interest on millet belated payment of gratuity and leave salary. And millet 120 days.
Leave encashment.
Leave it.
May 2025.
Fine.
You are for the state.
Yes.
Disposed of. দেখে নেবে correction.
Item number 9.
Let similar pay millet. Retired on millet 31st of July 2025.
Same prayer.
Millet.
31st July 2025.
Fine. 31st July 2025.
Date. Disposed of.
Okay.
Item number 10.
Similar term. Retired on Miller. Retired on Miller.
Date is not represented. Affidavit of service you have served upon all.
Yes, yes.
Retired on.
Retired on Miller, 31st of May 2025.
Otherwise, same prayer.
Yes.
Disposed of.
Item number 11.
এই শোনো, লাস্ট যে অর্ডারটা হলো না, ওটা স্টেট
Melody. Melody, in item number 12, I was appearing on behalf of the petitioner. Melody, your lordships is muted, Melody. Can't hear your lordships, Melody. Melody, your lordships is muted, Melody.
শুভজিৎ কোথায়? এই কি বলছে মিউট করা আছে?
No, my lord, now your lordships is audible, my lord.
Yes, yes.
I appear on behalf of the petitioner, my lord. The service in respect of respondent number 3 is not complete, my lord. I was humbly praying for completion of service in respect of respondent number 3, my lord. This is the Executive Vice Chairman, Comprehensive Area Development Corporation.
What you are praying for?
My lord, the petitioner was engaged as a contractual worker, my lord, with the West Bengal Comprehensive Area Development Corporation. There were various notifications, my lord, by virtue of which the petitioner's remuneration was enhanced. The petitioner retired on 20th of November 2025. Prior to his retirement, my lord, there was a notification which was issued on 1st April 2024. Apropos which, my lord, the petitioner's remuneration was enhanced to a certain amount as stated in that particular notification. If your lordships would kindly give me the liberty to place that notification once before your lordships, my lord.
Page?
It's P9, my lord. Page 62, my lord.
Yes.
Sorry, my lord, it's P7, page 59. I'm extremely sorry, my lord. Page 59.
Well, you serve notice upon the corporation without hearing corporation. Have you
Yes, my
served
lord. So that-
notice?
yeah, we have served, my lord. Only respondent number 3, the notice has come back as addressee moved, my lord. I was humbly praying if a liberty be given to me to serve upon respondent number 3 as well as the other respondents, my lord. There are 2 other similar matters which have been posted on 3rd of February, my lord.
Administrative Secretary, West Bengal Comprehensive. Have you served upon respondent number 4?
Yes, my lord, we have served upon the respondent number 4. It's by way of hand service. I'm actually sorry, my lord, I'm doing it virtually. I would have carried the affidavit of service before your lordships, my lord. I'm extremely sorry, my lord.
So why service could not be effected upon respondent number 3?
My lord, the addressee has been moved, my lord. Now it's in Salt Lake. The address mentioned here is Shubodh Mollik Square, my lord.
Then how respondent number 4 received it?
My lord, we came to know subsequently from the client, my lord, that their address has moved to Salt Lake. So we served upon respondent number 4. I have requested the client, even for respondent number 4 also, it came back to us, my lord. We thereafter, by way of hand service, communicated the respondent number 4. Insofar as the respondent number 3 is concerned, my lord, I have requested the client to provide the latest address. I'm yet to receive, so I was humbly praying if an accommodation could be provided to me, my lord,
Sure.
we'll serve upon the respondent number 3. The rest of the
The
respondents have
time
been
of
served.
call, learned advocate representing the petitioner appears virtually and prays for accommodation to complete service notice upon all the respondents. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon all the respondents by directed to serve notice upon all the respondents by fortnight by 10 days from date and file affidavit of service on the next date. List the matter under the same heading for further consideration on 9th February 2026.
Grateful.
Next.
Item number 13.
But here, Millet, retired employee of CSTC, Millet, praying for only 120 days leave salary. Millet, similar order, your lordship had it pleased to pass earlier, Millet.
What is your instruction?
Lordship, if similar order is there, Lordship, then
When retired?
I'll tell you, lordship. Retired on Millet, 31st of July 2020.
20?
2020. 31st of July.
So when you are why you are coming after 5 years?
Like earlier occasion Millet, since nobody were getting Millet, extra Millet 120 days. Millet, since subsequently it started from the last.
Then you are the fence sitter. Now, having found that the others are approaching this court, now you approach. Now you retired 5.5 years back.
Leave it to your lordship, Millet. Because this struck me also. Since last 6 months, Millet, they were getting all mostly drivers and conductors. Millet.
But it is memo dated 17 September 2009. Then why 2020 retiree will not get?
Lordship, there are some difficulties.
Money details in terms of clause 9 of memo dated 17 September 2009. If it is memo dated 17 September 2009, I could understand if the memo relevant memorandum was issued after the retirement of the petitioner. If memorandum was issued much prior to retirement of the petitioner, retired in 2020 and memo was issued in 2009, then petitioner is covered by this memo to take decision.
Completely.
And it is not a case of creation of third party interest.
No.
You have made a representation.
My page 30.
Page
Page 30, 30.
30.
And except P5.
No, this is advocate's letter. This is not your representation. It's a demand notice. That will not do.
Very well,
Very well, I'll grant leave to the petitioner to make. Where is that order?
Okay. This is the petition, this is the order, my lord, where your lordship had given. Correct. One kind of order. That order is not with me, Millard, but Millard, in earlier matters, Millard, that part, the final part, your lordship had given me liberty to, Millard.
That I know, but
Yes,
this order was a
yes,
specific order I have passed.
That order was also passed by your lordship.
Issue. Leave is granted to the petitioner. Nah, next paragraph. Having considered the submissions made on behalf of the petitioner and corporation, court finds no purpose would be subserved in keeping this petition pending. Next paragraph. Leave is granted to the learned advocate. Leave is granted to the petitioner to make a representation claiming leave in encashment benefits for a period of 300 days, not 180 days. To the Managing Director, Calcutta State Transport Corporation, being response number 5 by fortnight from date. Stop. If representation is made to the response number 5 within the aforesaid time, decision to be taken by the response number 5 in accordance with law. Stop. Response number 5 shall pass, next paragraph, response number 5 shall pass a reasoned order and same shall be communicated to the petitioner by time বললাম না না সেন্টেন্সটা এবার বলো by 12 weeks thereafter. Decision response number 5 shall pass a reasoned order and same shall be communicated to the petitioner by 10 days thereafter. Next paragraph. Read petition as disposed of urgent
I'm for the statement.
এই প্যারাগ্রাফটা চেঞ্জ হবে আগে যেটা আছে ঠিক আছে এই প্যারাগ্রাফ 4 প্যারাগ্রাফ হচ্ছে কি বললাম ডিসপোজ অফ তার আগে এই প্যারাগ্রাফটা এটা চেঞ্জ করলে এটা তো বলে দিলাম তোমার আচ্ছা এইটা অ্যাড হবে এটা থাকবে in the event decision is taken to enhance leave and benefit consequential steps shall be taken by the concerned responding authorities for releasing same to the petitioner এটা অ্যাড করে দেবে তারপরে একটা প্যারাগ্রাফ তারপরে ডিসপোজালের প্যারাগ্রাফ Which person has disposed of or been accepted? Next.
Item number 14.
Lordship, I appear for the petition.
Good answer for the respondent.
Lordship, the case of the petitioner is that he participated in the appointment process in this staff selection commission for the post of a constable. He was called for the detailed medical examination and he was rejected on the ground of LVH, which means left ventricular hypertrophy. The left wall of the ventricle gets thickened and the pumping capacity of the
valid reason.
Now your lordship,
under the revised guidelines.
Now your lordship, he appears for the RME. There also he was rejected. He subsequently gets himself tested with the AIMS and as well as with the PG, Calcutta, and found to be medically
Any
fit.
cardiological problem, a candidate is not is entitled to be part of discipline force. And there is a specific provision in the revised guidelines of May 2015.
Lordship, he is found to be totally fit. Subsequently by AIMS,
the parameters are different. For testing medically a civilian by a general physician or general hospital and testing a candidate for recruiting in a discipline force, object is completely different.
Lordship, one more
I have decided the issue. So therefore, it is left ventricular as it is LVH, hypertrophy. It's not a, because it's an enlargement of veins.
Lordship kindly comes to page
Sorry.
18 and 19. The report of the AIMS, it clearly harps on that the LVH is perfectly correct.
Because in case of medical examination by general physician or by hospital, they are not to follow the guidelines. For medical examination by the medical expert in review medical examination or detailed medical examination, they are required to follow the guidelines.
Lordship,
So there is a difference. Court cannot, and court is not a medical expert.
Guidelines prescribes that it should be within the vicinity of a medical college or hospital. But the entire examination was performed in a temporary unit by the medical board. That should also be taken into consideration.
If he is not cardiologically fit, what protection he will give to civilians?
Lordship kindly comes to page 23 and 24. There is a detailed cardiological report which has been obtained. He has submitted himself for test by the before the.
What protection he will give to the general to the citizens?
Your Lordship kindly comes to page 23 and 24. It has given a detailed medical report.
Left ventricular hypertrophy.
Left ventricular
hypertrophy. When heart's main pumping chamber walls thicken and enlarge.
Thickened and enlarged. Your Lordship, that cannot be subjective. That kindly comes to page 23.
You can do other work where you are not required to provide safety and security to others. But if you are a member of a discipline force,
Lordship kindly comes to page 23 and 24. Kindly comes to page 23 and 24. That's a detailed examination report by the AIMS.
do you have any instruction?
Yes, I have instruction. After the detailed medical examination, he was given a review. Medical examination was been done, and it's found as LVH, which means that the main pumping chamber of the heart at the left ventricle was become thin.
That is known to everybody.
Yes.
What further instruction you have?
No further.
Where is the relevant provision which makes the petitioner disentitled to be considered for appointment? That instruction is required.
That has I have the medical guidelines 2015. I have it is R3. I have it.
Which clause? It's a thick, voluminous guidelines.
Para 6. General condition for rejection. Indication of chronic disease like tuberculosis and other venereal disease, bronchitis, indication of general impaired constitution, any degree of deafness, loss of degree. This is a para 6. There is one of the
There are several parameters provided in these guidelines. And for LVH, there is a specific clause. Are you aware of that?
Clause 20.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces. Stop. Petitioner participated in review medical examination and was declared unfit since he was diagnosed with left ventricular hypertrophy within bracket LVH. Next paragraph. Union of India is represented by learned advocate. Next paragraph. Concerned respondent authority is directed to file a report disclosing as to why petitioner was declared medically unfit based on revised guidelines of May 2015. Stop. Next paragraph. Let such report be filed by 3 weeks from date. List the matter under the same heading for further consideration on 9th February 2026.
No liberty to file any exception.
Next matter, no, nothing is required. What exception?
Item number 15.
Petitioner is Millard, retired employee of Millard, West Bengal Transport Corporation.
Filed by the West Bengal Transport Corporation, my lordship.
Erstwhile Calcutta Tramways Company Limited. My Millard, prayer is Millard. May I hand up? What is it? Related payment of Millard's Provident Fund. Interest on Millard, related payment of Provident.
So you are claiming interest on Provident Fund?
Yes.
When retired?
Retired on Millard, 30th of November 2023.
Both of you are representing Transport Corporation? State. 6%, 3 months. Disposed of. Do you want to submit anything?
My lordship, one small submission, my lordship. For the fund, I'm dependent on state, so may the state be directed to release the fund, my
একটা
lordship.
লাইন অ্যাড করে নিও তুই আগেরগুলো
I'm grateful, my lordship.
For making payment in terms of the aforesaid directions, if fund is necessary to be allotted by the state respondents, comma, steps shall be taken by the state respondents for allotting such fund.
I'm grateful, my lordship.
ওটা add করে দেবেন।
I'm grateful.
Next.
But,
Item number 16.
similar prayer. Retired on minute 31st of May 2024.
Interest on provident fund.
Fine.
Yes, my lord.
State, you are for the state. Thirty-first May 2024.
Fine. 31st of May 2024.
Paragraph 6 এর পরে ওই প্যারাগ্রাফটা অ্যাড করে দেবেন। Disposed of.
Item number 17.
Similar prayer, Miller. Retired on Miller 29th of February 2024. 29th of February 2020.
2020.
2024. 29th of February 2020.
You are for the state. Who is your senior? Vikas Goswami. Where is he? অর্পণ এটা নিয়ে যাও। এই যেটা অ্যাডিশন করলাম প্যারাগ্রাফটা একটু বলো তো। If fund is necessary to be allotted by the state respondents. সেম ওটা শুধু ডেট অফ রিটায়ারমেন্টটা চেঞ্জ হবে ডিসপোজড ওটা একটু ওকে দিয়ে যাও ওই প্যারাগ্রাফটা ওর লাগবে নেক্সট
Item number 18.
Same prayer.
রিটায়ার্ড অন
29th of February 2024.
ইন্টারেস্ট অন প্রভিডেন্ট ফান্ড
Minor.
February 2024
Minor. 29th February 20.
state শুভেন্দু এই অর্ডারটা ধরেই করবে কারেকশনস গুলো ঢোকাবে আর ওই একটা প্যারাগ্রাফ ওকে বলে দিচ্ছে স্টেটের ফান্ড অ্যালটমেন্টটা ওকে বলা আছে ডিসপোজড অফ
Item number 19.
when retired
31st of October 2024.
interest on provident fund
Minor.
here for the state
Yes.
disposed of
Item number 20.
Retired on Millet, 31st of October 2024.
Disposed of.
Item number 21.
Retired on 31st of July 2023.
Fine. 2023. You are for the state. Disposed of.
Item number 22.
Tag on millet. 30th of September 2024. 30th of September 2024.
Who is for the state? Disposed of.
Item number 23.
Tag on millet. 31st of October 2024.
Lordship, I'm for state, Your Lordship.
Why?
Because Landed Senior is my Devashish Chattopadhyay is for the state actually. I'm his junior.
Why he has not come?
He's not well, Your Lordship. That's
You are not in not.
panel, Your Lordship.
That is sufficient. Thirty-first October 2024.
Fine. 31st October 2024.
Give your name. You are appearing in this matter? Yes?
I came here behalf of my senior actually.
You are not engaged in this matter?
No, your lordship. The
Very
papers
good.
belong to my senior.
তাহলে ওই স্টেটের অ্যাপিয়ারেন্স দেখি আমায় দাও। স্টেটের অ্যাপিয়ারেন্স তো দিও না।
Item number 24.
Retired on Millet, 31st of August 2024. Only PF.
হ্যাঁ, 31st August 2024.
31st of August 2024.
And PF paid on 26 May 2025.
Here for the state. Disposed of.
Item number 25.
In this matter, Millet, paying for belated payment, interest on belated payment of provident fund, gratuity and leave service. All three Millet. All three were paid in at a belated state. The similar order.
Only you are praying for interest.
Yes, only interest.
When retired?
Retired on Millet, 31st of July 2024.
Interest on PF, gratuity and leave salary.
My
Here for the state. He was under the contributory provident fund scheme. এই শুভেন্দু, তাই না, কোনো কারেকশন এখানে নেই, কারণ এই নেসেসারি স্টেটের ফান্ড অ্যালটমেন্টটা বলাই আছে ছোট্ট করে, বুঝতে পেরেছো? হ্যাঁ, না, বিভিন্ন ফর্মে আছে, এই ফর্মটা ভালো, ছোট ফর্মে বলার দরকার নেই, শুধু এই পাতায় কারেকশনটা ডিসপোজড অফ। না না, ওইটা এক এক সময় এক এক রকম বলা হয়ে যায়।
Item number 26.
State. Yes.
Only
Retired on
retired on millet 31st of August 2024. 31st of August 2020.
interest on PF.
Only PF.
Disposed of. Give your appearances.
Item number 27.
Millet, only PF, Millet retired on 31st of August 2024.
Date. Disposed of.
Item number 28.
This pertains to millet, interest on millet, PF gratuity and leave salary.
Retired on
Retired on millet 31st of March 2023.
you are for the state. 31st March 2023.
2023.
Interest on PF gratuity leave salary.
Yeah, leave salary.
এই শোনো ও এটা আছে এই প্যারাগ্রাফটা অ্যাড করে দিন। ঠিক আছে করা যাচ্ছে ডিসপোজ কারেকশন গুলো ফার্স্ট পাতে আছে দেখে নিন।
Item number 29.
Only provident fund millet.
Interest and provident fund.
Only.
Retired on
Retired on millet 31st of October 2024.
who is for the state. এই শোনো এটা প্যারাগ্রাফ 7 দিয়ে দেবে 7 অ্যাড করবে if necessary state government shall allot necessary fund if necessary comma state government shall allot necessary fund stop তারপরে 8 9 হয়ে যাবে পরের প্যারাগ্রাফ ডিসপোজড
Item number 30.
I am for the state.
Similar prayer millet. Only PF millet. Retired on millet 30th of September 2024.
30th September 2024.
30th September.
Interest on PF.
Only.
ওই প্যারাগ্রাফটা যেটা বললাম আগে সেটা অ্যাড হবে এটাতে 7 হ্যাঁ সেম জাস্ট আগের ম্যাটারটা ডিসপোজড অফ
Item number 31.
I pay for the respondent.
Yes.
The outset with regard to PFF of 2024, man. And
জাস্ট এই একবার সোমনাথকে একটু দেখো
PFF 2024. And I'd like to point out your lordship because this has been filed after 13th of December 2025.
What remains?
As regards whether there are if there is
If selection process is over and now if
it has not been published.
maybe, but after initiation of the fresh selection process, the previous selection process came to an end, and you have filed the writ petition when there was the previous selection process was not existing.
So no final merit list has yet been.
What prevented you to approach the court within time?
It has come before your lordship. Kindly consider this matter once.
And when the present selection process started?
Sometimes
Notification?
I will have to take instructions, my lord, with regard to that, my lord. I'll
Yes, yes, you have just submitted. When started?
Perhaps in October, of October 2025. Well, merit list has already been published on 12th March 2024. Well, 13th December 2024.
13th December
2024. Again, I submit repeatedly, my lord, this is not a merit list, that is a selected list, my lord. Repeatedly, this is being said and submitted before your lordship. That is a selected list, not the final merit list.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph.
Only one thing, my lord. May I just, for your lordship's assistance, if your lordship kindly comes to page 32, my lord. Tremors in hands, closing eyes, my lord, and it has been
not required. Please hear the
court. Only for your lordship's assistance. There's also a judgment, my lord.
Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces within bracket CAPFS. Stop. The selection process where petitioner participated was of 2024. Stop. From the submissions made on behalf of the parties, it appears Selection process for the year 2025 commenced in the meantime, and merit list was published on 13 December 2024, whereas present writ petition was filed on 23rd December
My lord,
2025.
that is not a merit list. Kindly not record.
13
my lord.
December 2025 koro.
My lord.
13 December 2025
2025. 13 December 2025.
25, whereas present writ petition was filed
24. My lord, 24.
whereas present writ petition was filed on 23rd December 2025.
That is 13 December 2024. My lord.
Stop. Such fact goes to show that present writ petition was filed after initiation of the selection process for filling up the posts of constable GD under CAPFS
2024
for the year 2025.
That is not a
Stop. Next paragraph. There is no plausible explanation disclosed in this writ petition, which disclosed in the writ petition for delay caused in approaching this court in connection with the selection process of 2024. Stop. Next paragraph. It is tried that after initiation of fresh selection process of 2025 for recruiting the post of constable GD under CAPFS, previous selection process of 2024 comes to an end, and right of the candidate who participated in the previous selection process, that is 2024, is withered away. Next paragraph. At this belated stage, no relief can be granted to the petitioner. Stop. Writ petition stands dismissed. Or
One submission, my lord. It is not a merit list, my lord. It is a selection list of
Next
merit.
matter.
My lord, kindly, this recording is going to be a wrong recording, my lord. I am beseeching your lordship, my lord, kindly consider this. My lord,
Even then, that will not create any difference.
my lord, let them show that this is a merit list. my lord.
Please call the next matter.
This recording is a wrong submission that is being recorded by lord. My lord, this is a wrong submission that is being recorded.
অনেকগুলো ম্যাটার সিমিলার পর্ববর্তী হয়েছে ইন্টারেস্ট অন
That was a selected list. My lord, kindly, I am beseeching your lordship. Kindly.
Sorry.
It's a merit list of.
Please call the next matter.
Item number 32.
It will be a wrong recording and a wrong precedent will be set, my lord.
Item 32, my
Well,
lord.
kindly consider that.
I am appearing for the writ petitioner, my lord. My lord, the petitioner before your lordship was a probationary officer in UCO Bank, my lord. Now, my lord, a disciplinary proceeding was initiated against her, my lord, for not joining the transferred post. Proceeding was concluded and, my lord, inquiry report was submitted. Then, my lord, she was removed from service. Thereafter, my lord, she preferred a statutory appeal.
Probationary officer in UCO Bank,
Probationary officer. He was a permanent employee.
who is for the bank authorities.
My lord, well, this is the affidavit. Now, my lord, she was removed from service. Thereafter, my lord, she, as per rule, my lord, she preferred a statutory appeal. That was rejected. Then she preferred a review application. That was also rejected, challenging the disciplinary proceeding and the order of removal, my lord. She filed this writ petition. My lord, there is no scope of any interim order.
But there is no appellate authority.
There was an appellate authority. She
That
preferred an
appeal was availed of.
Yes. that
Appellate
was
authority
rejected.
affirmed the order of the discipline authority.
Yes. My lord, there is one thing, my lord, I found, my lord, from the writ petition that certain documents in pertaining to the inquiry, my lord, were not annexed to this writ petition. I have prepared a supplementary affidavit and I am seeking leave, my lord.
Have you served upon copy of it? Where is the order of the appellate authority?
Yes, my lord. The order of the appellate authority is at page 68, my lord. 68 of the writ petition. This is dated 31st of May 2025.
কারাবাসটা কোথায় এটা বলবি তো?
হুগলি।
This is the order of the appellate authority.
Yes, my lord. And the order of removal, your lordship will find at page 60, my lord.
So why you are coming after 6 months?
No, 6 months, my lord. Thereafter, I prepared a review application.
The review order of the
This order, my lord, that your lordship will
9 July 2025.
9 July 2025, I filed. That is that was
Review.
dated on 1st
You
November.
file review, then 1st November is the order of the reviewing authority.
Page 78.
So challenging disciplinary authorities order, appellate authorities order, and reviewing authorities order you have. And the punishment which has been imposed is removal,
Removal.
not future disqualification for, not a disqualification for future employment.
That condition was.
And what is the order of the disciplinary authority?
Yes, my lord. That is at page 60, my lord. At page page 63, man.
Yes. What is the
Penalty. My lord,
page?
your lordship will
Where is
find.
the where is punishment recorded?
Yes, my lord, page 63. In the end of the page, there is a box. Right
Yes,
hand side, your lordship
table.
will find penalty imposed.
Oh. Remote from service. There's no scope for any interim order. Full-fledged inquiry was conducted.
Witnesses were examined.
Inquiry report was supplied to you. You responded to the inquiry
That
report.
was
Second
because
show
we
cause
have
notice, everything.
Yes,
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. One supplementary affidavit is filed on behalf of the petitioner and same is also taken on record. Stop. During course of hearing, copy of the supplementary affidavit is made over to the learned advocate representing bank authorities. Bank authorities. Next paragraph. In the writ petition, order of the disciplinary authority dated 27th March 2025, whereby petitioner was directed to suffer removal from service, directed to suffer punishment of removal from service, is questioned. Stop. Order is questioned. Order क्यों ना order of the disciplinary authority बोला था तो dated 27 March बोले थे तो हाँ is questioned. Stop. Next paragraph. Order of the disciplinary authority dated 17 March 2025 was appealed against, and appellate authority video order dated 31st May 2025 affirmed the order of the disciplinary authority. Stop. A review application was preferred before the revisional authority questioning order of the appellate authority, and same was and the order of the appellate authority was affirmed. Video order dated 1st November 2025 passed by the revisional authority. Stop. In next paragraph, in the writ petition, orders dated 31st May 2025, order dated 31st May 2025 and 1st November 2025 passed by the appellate authority and revisional authorities respectively are also questioned. Respectively, pore comma diye are also questioned. Stop. Next paragraph, having perused the impugned orders, court finds there is no scope for passing any interim order. Stop. Next paragraph, validity and legality of the impugned orders are required to be decided on exchange of affidavits. Next paragraph, let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph, petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
Great.